Hi, I'm Deb Sullivan, and I'm here today to talk about Weingarten Rights. These rights only extend to union workers. Weingarten was initially created when the Supreme Court agreed with the National Labor Relations Board decision that employees have a right to union representation at an investigatory interview. These rights are not found specifically in the NLRA, National Labor Relations Act, but exist because of a case that was decided on February 19, 1975 in NLRB versus Weingarten, Inc. They are an interpretation of Section 7 of the Act. In a nutshell, Weingarten provides the following. Union representation requested by employees at employer-initiated inquiries are considered as concerted activity for mutual aid or protection. The Supreme Court established some rules for the investigatory interview. First, the employee themselves must make a clear request for union representation before or during the interview. Once the employee request is made, the employer can 1. Grant the employee's request and give the union representative an opportunity to consult with the employee. 2. Refuse the request and end the interview immediately. 3. Give the employee a choice, end the interview, or proceed without representation. If the employee request is denied and the employer continues to ask questions, an unfair labor practice, or a ULP, is committed because the NLRA was violated. The actual language reads like this. If this discussion could in any way lead to my being disciplined or terminated or affect my personal working conditions, I respectfully request a union representative be present during this meeting. Until my representative arrives, I choose not to participate in this discussion. Some really important things to remember. You must have a reasonable belief that discipline will result from this meeting. You have the right to know the subject of the meeting. You have the right to consult your representative before the meeting. You, as an employee, must request the representation. You do not have the right to refuse to attend a meeting if your request for a representative is denied. But you can continue to repeat your request for representation to the manager conducting the interview. You can take notes and respectfully refuse to answer questions. You do not have the right to a union representative of your choice. Representation may be based on the availability of the rep. Just as an aside, Weingarten rights do not apply if the employer is simply informing you of discipline which has already been determined. They only apply if you are being questioned. Remember, these are your minimum legal rights under Weingarten. Some contracts may have additional rights, yet one more reason to read and get familiar with your own collective bargaining agreement. If you would like to learn more about the world of labor and management relationships, you can access the Labor Guild's video series or enroll in the Guild's School of Labor Management Relations. Thank you for taking the time to watch this video.